If someone tells you, "I'll see you in court," what does that actually mean? We've all seen the fast-paced courtroom dramas on TV, but the reality of civil litigation here in Pakistan is quite different. Welcome to this explainer. If you're a prospective litigant, a law student tackling the Code of Civil Procedure 1908, or just someone looking to understand how the system really works, you are in the exact right place. Today, we're going to break down the entire civil lawsuit process step by step, from the moment a dispute arises to the moment a court delivers its final judgment, and even what happens after that if a losing party refuses to comply. We're going to follow a clear 5-step roadmap today. First, filing the civil suit. Second, framing the legal issues. Third, the evidence stage. Fourth, the judgment and the decree. And finally, enforcement and appeals. Let's jump right in. Step 1. Filing the civil suit. This is where the entire journey begins. Every lawsuit starts with a dispute. Maybe it's a disagreement over a property line, a business loan that was never paid back, or a breach of a commercial contract. Before even stepping foot in a courtroom, a lawyer will usually send a formal legal notice to the other party. It's essentially a final demand to fix the issue, and it shows the court you tried to be reasonable. If that fails, we move to filing the actual paperwork and then formally notifying the defendant. But before any papers are stamped, we have to pause and ask some very hard legal questions. We need to figure out if you actually have what the law calls a cause of action. Simply put, has a recognized legal right genuinely been violated? If so, who exactly are you suing, and in which specific court? This is about jurisdiction. Does the court have the authority to hear this type of case, and is it in the correct geographical area? I can't stress this enough. Countless cases are thrown out at the very first hearing just because they were filed in the wrong court or by the wrong person. A solid legal assessment upfront literally decides if your case survives day one. Once you're certain of your ground, you file your foundational document. Under Order 7 of the Code of Civil Procedure, this is known as the Plaint. Think of the plaint as the absolute blueprint of your lawsuit. It lists the parties' names, the exact facts of what happened, the specific relief or compensation you want, and the monetary value of the suit so the correct court fees can be calculated. Careful drafting here is absolutely crucial. If your plaint is defective, maybe it's missing key details or the court fees are short, the judge can reject it entirely under Order 7, Rule 11. No trial, no arguments, just rejected. It has to be rock solid. When the court accepts your beautifully drafted plaint, they issue a summons under Order V. This is an official court order sent directly to the defendant, basically saying, you are being sued and you need to appear in court on this specific date. Making sure this summons is properly delivered or served is a massive deal. It might be delivered by a court official sent via registered post, or if the defendant is actively dodging the court, published in a local newspaper as substituted service. If you win a judgment against someone who is never legally served, they can easily get that judgment completely set aside later on. You absolutely do not want to derail your case over a delivery error. Moving on to Step 2, framing the legal issues. This is where the court starts cutting through the noise. Now that the defendant knows they are being sued, they have to respond by filing their written statement, which leaves the judge to officially frame the parameters of the trial. The defendant is given a fixed amount of time to submit this written statement. This document is their official side of the story. In it, they will admit to certain facts, deny others, and raise their own critical legal defenses. They might argue that the time limit for the lawsuit has expired, or again, that the court lacks jurisdiction. For a defendant, this written statement is arguably their absolute best shot at killing the lawsuit early on technical grounds before a drawn-out trial even begins. Once the plaint and the written statement are both on the record, we reach a really fascinating stage under Order 14, the framing of issues. The judge steps in and acts like an editor. You see, not every single fact in a lawsuit is actually debated. The judge sifts through the documents, strips away all the things both sides already agree on, and identifies the exact points of conflict. These are the issues. From this moment on, the upcoming trial will revolve exclusively around resolving these specific contested points. It provides a laser focus for the rest of the case. That brings us to Step 3, the evidence stage. This is the absolute heart of the trial. Now it's time for both sides to actually prove what they've claimed, starting with the plaintiff and then the defendant. This relies heavily on witness testimony, which follows a very strict timeline. First is the examination in chief, where a witness tells their story to the court. Next comes the cross-examination by the opposing lawyer. And let me tell you, cross-examination is genuinely where cases are won or lost. A witness's story can seem perfectly solid until a skilled lawyer starts poking holes in it. Sometimes there's also a brief re-examination to clarify things.
Alongside this oral testimony, the parties are also submitting all their hard documentary evidence, things like contracts, bank receipts, property deeds, and expert reports.
But it's time for a reality check. While recent procedural reforms have tried to speed things up, the evidence stage is notorious for its delays. Why? Well, frequent adjournments, witnesses simply failing to show up on their scheduled dates, and lawyers filing various procedural applications mid-trial. Because of all this, getting through a single witness's testimony can sometimes drag on for months. This is exactly why civil litigation in Pakistan requires an immense amount of patience.
Eventually, the evidence concludes, final arguments are made by the lawyers, and we reach step 4, the judgment and the decree. This stage under Order XX often confuses people, so let's break it down clearly. The court's final decision is actually split into 2 distinct parts. First, you have the judgment. The judgment is the detailed, reasoned explanation of the judge's findings on every single issue that was framed earlier. It's the why. But based on that judgment, the court draws up something called the decree. The decree is the formal, operative part of the decision. It legally defines exactly what each party is physically or financially entitled to. So the key takeaway here is that while the judgment contains the court's legal reasoning, the decree is the actual tangible order that gets enforced in the real world.
Which naturally leads us to our final section, Step 5, Enforcement and Appeals. Winning a brilliant judgment on paper doesn't magically put money in your bank account or give you your property back. If the losing party stubbornly refuses to comply with the decree, the winner, now called the decree holder, has to initiate execution proceedings under Order 21. This is where you formally ask the court to use its state machinery to force compliance. The court can do this by attaching and auctioning off the losing party's property, garnishing their bank accounts, or even sending the police to forcibly hand over physical possession of a disputed piece of real estate. You'll often hear experienced lawyers call the execution stage the second round of litigation. It's a sobering nickname, but a highly accurate one. Losing parties rarely just give up. They will routinely file fresh objections during execution, challenging how a property was attached or throwing up entirely new procedural roadblocks. This can easily add months or even years to the timeline before the victorious party actually secures their hard-won relief. And of course, we have to consider what happens if a party firmly believes the trial judge simply got the law or the facts wrong. The Civil Procedure Code provides several layers of remedies for this. First, there's a first appeal, where a higher court looks comprehensively at both the facts of the case and the application of the law. If that fails, a second appeal might be possible, but typically only if there's a substantial question of law at stake. And in situations where an appeal isn't legally allowed, a party can file a revision petition to correct serious jurisdictional errors. These checks and balances exist to ensure fairness, but it does mean that a trial court's judgment is rarely the end of the story. So let's look at the big picture, from the initial dispute, drafting that foundational plaint, battling through the evidence stage, all the way to securing a decree, executing it, and potentially fighting appeals. That is the real journey of a civil lawsuit. Understanding this roadmap is absolutely crucial. It sets realistic expectations from day one, whether you're a litigant preparing for the long haul or a law student mapping out the code of civil procedure. Navigating this system takes time and resilience, but knowing the exact steps involved is your very first advantage. Which specific stage of this process would you like us to dive deeper into next time? Let us know. And if you found this explainer helpful and want to continue mastering the practical side of Pakistani law, be sure to subscribe to Pakistan Legal Insight. We'll see you in the next one.